This is pre-recorded video evidence for the London Employment Appeal Tribunal case against Lidl, Great Britain and others. Case reference number 828. Case was submitted in 2021. There are three files which I would represent you within just half an hour. It's a skeleton argument. There are 5 points for grounds of appeal, because there are 5 grounds of appeal on which I have based my appeal. And also I will read you a short 1 page with key dates, natural chronology of my service in Lidl, process of my disciplinary, prior investigation and prior unfair suspension. I used to work in Lidl for over 10 years. I collected 13 payslips in a row, and I have mathematically proved that Lidl are deducting approximately from the part-time employee as me with 20 hours per week contract, approximately £2,400 each year. I'm starting with a skeleton argument. First is claimant continuously complain for victimization by Brendon Kane and Mohammed Sobahadin, and also for the wage scam on the following dates: 3rd of November 16, 20 of November 16, 10 and 22 of December 16, 6 of March 17, 13 of April 17, 25th of May 17, and 8 of June 17. It's all these complaints was in written, and they could be found on the pages 73, 122. The first claimant bundle. All links for the bundles also in the description for the video. On the 25th of May 2017, claimant gave the notice to leave after 14 days on the 7th of June 2017. Claimant was covertly then suspended only on 8th of June 17, 1 day after the final day. The first letter was issued only on the 12th of June 2017. All this was continuously repeated to the Employment Tribunal during 4 years between 2017 and 2021. But judge ignored to record any of such facts. Judge inverted to the core of the victimization claims as the single episode on the 4th of February 2017 with Mr. Brendon Kane, just a day prior his forced suicide. Question is, why does the judge exclude pillars of the documented victimization claim against Mr. Mohammed Sobahadin by derailing to a single episode with deceased Brendon Kane? Claimant requests the Employment Appeal Tribunal re-examine the victimization claims. Second skeleton argument for the second ground of appeal, to which I will go later, is the following. Claimant is disabled person with a paranoid personality disorder. The full GP evidence was provided in time. In the 29th of September 2018, all these documents could be found in a second claimant bundle in the Employment Tribunal in the pages 121, 158 to 110. Further, Employment Tribunal apologized for their own fault, still requesting such data on the 19th of October 2019. After more than 1 year, 13 months, they just re-requesting the same evidence which they had, and they finally apologized for it. Judge Manley deliberately wasted another year gap, which allowed respondent to destroy some still undisclosed files, such as the written complaints about physical abuse and threat with weapon on the 25th of May 2017 and on the 30th of May 2017. 3 years frame, because the case in the court already for 5 years, but 3 years frame allows respondent legally to destroy these never existing files. Since the COVID era, 2020, just between 20th of April 20 and 19th of May 21, it were 2 preliminary hearings and the final hearing, full hearing, with the pre-drafted decision in a backdated 2017. However, the judge manipulated as a COVID delays, which is inadmissible. Judge states that a range of the admissions relevant to claimant mental health took place, but did not outline at least one, and reason none. Additionally, on the 20th of April 2020, the judge disconnected claimant from the telephone hearing and had conversation with respondent in private about how Employment Tribunal will keep ignorance to all claimant applications. Finally, the judge advised to respondent to make an application under the Rule 37, which is a scandalous, vexatious, unreasonable behaviors during the procedures and legal procedures. Due to the Employment Tribunal technical fault, claimant was simply muted but not disconnected. Claimant has heard the full chat, while judge believed that she spoke to respondent in private. It is recorded, and the transcripts could be found on the second claimant bundle in the Employment Tribunal pages 270-280. Question is, did judge comply with the part 2 of the judicial conduct? Claimant requests Employment Appeal Tribunal to order Employment Tribunal to rehear the case on the recorded regime. Argument number 3 to support ground of appeal number 3. The full absence of the intellectual honesty and impartiality within wage claim. Claimant requests Employment Appeal Tribunal to order Employment Tribunal to rehear the wage scam case because the request to explain the wage system was made after the first pay in 2016. It was continuously repeated during the employment, during 37 weeks, and the disciplinary process, which took 18 weeks. The payroll answer appeared only after a year in 2018. See first claimant bundle on the pages 265-277. However, it didn't satisfy the judge, and on the first preliminary hearing in 2018, it was ordered by judge to provide the witness statement explaining the pay system. The witness statement is provided by the payroll head, by the head of the payroll, on the 19th of September 2019. But it's unsigned and was never, up to now, added to respondent bundle. On the 15th of October 2019, just less than 28 days after this witness statement, claimant submitted the Annex K, which is the full, detailed mathematical breakdown on the unfair, dishonest, and manipulated calculations. For the full range of the examples of the intellectual dishonesty, see file appeal, particularly points 3 and 29 to 32. The simplest from dozens examples will be the fact A and B. Fact A is that during my employment on the 4th of April 2017, by the end of the financial year, payroll agreed that all claimant pay slips, which are now in the case and the respondent are making his calculation according to these pay slips, on the 4th of April 2017 it was agreed as incorrect and need to be recalculated. However, it was never recalculated. See all these proofs in a transcript of such a recorded chat with the payroll on the 4th of April 2017. The transcripts could be found in the first claimant bundle between pages 108 and 110. In some months, respondent even failed to pay national minimum wage. During those 13 payments, respondent stole from claimant £2,425 and 52 penny. However, after over a year, respondent is still using the incorrect payslips, as it was just explained. Finally, respondent built own calculation on the base of the contract, generally in Lidl, 5 days a week, 20 hours a week, while claimant contract was amended and was special contract with only 3 nights a week and 20 hours per week. The Annex K is the deep mathematical breakdown of the own 13 payments, which additionally split in the sub-bundles according to the following: contract hours, overtime, nights, London allowance, night shift leader, holiday, statutory sick payment, and etc. Despite all above, the judge ignored to comment on the Annex K for over than 2 years. Then, without any grounds, it was labeled as difficult to follow, which is the impartiality and intellectual dishonesty. The wage deduction claim must be reheard. Respondent indeed stole £2,425 52 penny. We go on to argument number 4 to support ground number 4. Employment Tribunal failed on the requirement of the section 7 subpoint 3 subpoint E of the Industrial Tribunal Act 1996. Particularly, the complaint reports mentioned in a skeleton argument, C point 1 above. Also, respondent didn't comply with the numerous ET orders, and then the judge was ignoring claimant requests for the unless orders for over 3 years. The requirements of the witness evidences, which is the section 7.4b of the same Act 1996, were also failed on the claims for the victimization and protected disclosures. On the 20th of April 20, Employment Tribunal rejected claimant request for witness evidence without giving a reason that is not relevant yet. De facto, it never became relevant, as monthly was unfair. The Employment Appeal Tribunal must order the witness evidence by management to whom protected disclosure were made. Also, 2 team members who were threatened and with weapon and beaten by claimant must be questioned, as the written reports from 24th of May 2017 and 30th of May 2017 are still undisclosed. Respondent witness statement about pay issue must be examined, and it will take approximately 2 hours. And it should be done on the basis of the claimant Annex K, which we could find it on the second claimant bundle between pages 136 and 151. Number 5, to support ground number 5. The key dispute before the decision was made in the procedures 2017-2021 was claimant right for audio recording. As on a few occasions, judge refused to recuse herself. Judge misconduct was recorded, and this is why the regional Judge Foxall deployed a sleepy lay member cult and refused even audio recordings. Employment Tribunal failed to take any notes at all, despite that it was in the directions. However, it was taken by the claimant secretary and could be found in the Employment Appeal Tribunal bundle. The decision was just a matter of time, as it was made a long time ago, in 2017. The Employment Tribunal didn't know how to fit it, as even Employment Tribunal Form 3, dated 14th of February 2018, does not reply to the actual claim Form 81 by claimant, which was submitted 5 days prior it on the 9th of February 2018. It's nonsense. Even the party names are incorrect. Just look on 81 and 83. All this was completely ignored during 4 years. And indeed, 83 form is not the response to 81 form. After regional manager was involved in a forced suicide of my colleague Brendon Kane. Now, the next file, this is a legal statement for the Employment Appeal Tribunal case, reference number EA 2021-0082880. My name is Aliaksandr Drinkov. I'm suing Lidl during last 5 years. Case already passed Employment Tribunal and now in Employment Appeal Tribunal. The case has an official privilege from British government, particularly National Crime Agency, UK Border Forces and UK Visa and Immigrations, and Home Office to the different institutions. All these facts, when I'm stating about government influence on my life and on the legal cases, are set it in a legal number. It's 01CW0304A22EWY. And I would not waste your time on the facts to prove that MI5 had influence on my life. If you are interested, just go to this case and make your decision. But I'm stating that the government had gave this case against Lidl unofficial privilege because Lidl tried to sack me unfairly with the critically fake records which allow further for UK visa and immigration to not extend my residency status. I built my appeal on four main documents. It's a short chronology of my service in Lidl, 1 pages, 10-15 dates, key dates, grounds of appeal to Employment Appeal Tribunal, and skeleton of argument. It's only 3 pages. I will read them now, and these 3 pages actually are supported by the actual appeal, which is a decision based on 49 points in my appeal, because in these points I quotated fully judgments of the judge step by step, paragraph by paragraph, and in the 49 points of the judge, in every single point I showed clear fake manipulations, integrity, intellectual dishonesty, and obviously it was made by the marioneted judge Manley, and she led the case for 4 years. Now the case in the Employment Appeal Tribunal. Let's start from the short chronology of my service with Lidl. On 2016 I was living in Gibraltar, and very strange, I received an offer from Lidl. I even didn't apply. I was working in further when I came back to England. I started to work in Borehamwood on 11th of October 2016. And after the first pay slip, I started immediately complaining about the pay issues, because I had the experience already to get unlawful deductions back through Employment Tribunal through 2 different companies. It's Accor and Marks and Spencer, from where I was always sacked for the fact that I claimed unlawful wage deduction. All proofs and excuse from HR and payroll for the unlawful deductions are included in my case, and this is the fact what I'm saying. I was working for Lidl 7.5 months, and on the 24th of May 2017, the first written allegation against me was submitted to store manager. However, it's still not disclosed neither to Employment Tribunal, neither to me during the investigation, disciplinary and all legal process, and Judge Manley deliberately ignoring to request these fake reports, which indeed never existed. This report appeared because on the next day, they backdated this report with the fake evidence, because on the next day, on the 25th of May 2017, I had a meeting with the top bosses in London, UK, in London, from region. It was a area manager, regional manager, and well-being coordinator for all London. Susan Weiss, Adam Cateral, and Josh Styllanou. On this day, I gave them again complaint about unlawful wage deductions, and I also mentioned about inadmissible working conditions because of the staff disputes and behavior in store, and I gave the notice to leave, and I also submitted my academic essay about unlawful wage deduction and UK work relations. We agreed that my last working day would be 6th of June. On the 30th of May, after 5 days after this meeting, the second written allegation was submitted against me. For sure, like the first one, it's also not challenged to me at all. It's still not disclosed and was challenged to me only after suspension on the 10th of June 2017. On the 7th of June 2017, when it was the last day of my job contract with Lidl, by the notice which I gave on the 25th of May, I completed my shift and came back within a few hours to try to log in. However, it says suspended. No one could explain me why I was suspended from deputy manager. Just they told you are suspended. I thought how I could be suspended if I gave the notice to leave. No, you are suspended. I came back on the next day to store manager. He escalated all these issues. However, nothing for the next 4 days up to 12th of June was challenged to me at all. Lidl expected to create these fake records on the basis that on my last day I will just leave the job and will never know about the suspension, about the reason of suspension, investigation, etc., which will allow them to create any fake records on my name. Records was critically fake, like beating colleagues on the shop floor in the night time, and next day on the 30th of May, threatening them and abusing with the hacksaw. This is absolutely fake, and I was sacked for absolutely different evidence, but this still undisclosed report was used for the inadmissibly illegal suspension without any paperwork on my last working day. How I told on the 15th of June 17, the general suspension reason was given without any details, however. On the 28th of June, I complained again that my protected disclosure, which was escalated on the 25th of May, need to be dealt and responded, including pay issues. On the 26th of June, the same day, the investigation began. Still, no any particulars were not disclosed. So they started investigation after 21 days since I was suspended, but why in the details it was not explained. It was just said threatening, abusing colleagues. On the 2nd of August 2017, the first time when the allegations, fake allegations, were disclosed to me in written, in the letter which invited me to the disciplinary within less than 24 hours, within 17 hours. So the next morning they planned to do this disciplinary and sending me documents just less than 24 hours prior to the hearing. This is the point. This point very important because judge agreed that respondent was always working fair and the disciplinary investigation process was fair. Since August up to October, it was a couple of meetings where I defend myself. I didn't plead guilty. And on the 2nd of October 2017, 4 months since suspension, they made a final disciplinary hearing, and the disciplinary officer deliberately took the witness statement from the wrong assistant manager
and dismissed me for the various allegations that were raised. So it's not for that I beat colleague or threat them with the hacksaw. De facto, the new hacksaw in the package was in my bag with the tools in a staff room during the last 6 months with permission of 2 assistant managers. And on this investigation, I was always mentioning that they gave me this right to keep my tools, including a new hacksaw in the packages. However, in the disciplinary office, forgot his name, took the witness statement, not from these both, Colin Bevan, disciplinary officer, took a witness statement, written witness statement, from store manager, who was never been aware that I am keeping the hacksaw in a staff room, and I never get a permission from him, because I get it from 2 of his assistants. This is how they manipulated the fact, and they sacked me for keeping hacksaw new in the packages in a staff room. On the 27th of October, claimant approached ACAS for the certificate. On the 23rd of November 2017, ET procedures had started, and they were terminated after 3 years in 19th of May 21. Claimant bundle, 2 bundles in this employment tribunal case. It's a totally 600 pages, included the full set of the cooperation in the chronological order, from suspension up to the last day in tribunal, including case managements, orders, and also the EAT core bundle include the full set of all these judgments and case management orders during the last 3 years. Now we go into grounds of appeal. I'm bringing this appeal on 5 grounds, which is the errors in law. The ground number 1. Employment Tribunal, particularly Judge Manley, did not comply with the section 62 bracketed 4 of the Employment Tribunal Rules and Procedures 2013. The given reasons are challengeable in her judgment, in her reasons, and controversial, or not significant enough for dismissal due to whistleblowing on a wrongdoing about health and safety, and also the wage deductions. The continuous accusation by Mohammed Sobahadin are unquestionably in time. Judge removed any comment on the written complaints in June and August, since June to August, before the suspension up to the day when the disciplinary started. Judge did not allow to record any of the preliminary hearing, any verbal evidences, despite of the clear medical recommendations. Claimant is disabled person with the paranoid personality disorder, and medical evidence was submitted that audio recording or video recording of the procedures is in the best interest of the claimant mental health. Please consider the file appeal in full. File appeal, it's 32 pages where fully implicated the judgment of Judge Manley on the 19th. Highlighting each file's fabrication, manipulation of every 45 points of the judgment. It's self-sufficient file, and the judgment was fully pasted in. The reference were made just for the dates and for the fact verifications if it will be necessary, because the time I covered it's 3.5 years, and all these documents are sitting in a 600 pages bundle of the Employment Tribunal. Second ground of my appeal. ET did not comply with the part 2 of the judicial conduct, particularly judicial independence, dignity, impartiality, integrity, which is the intellectual honesty I meant. Claimant is unrepresented, disabled, and no any agreements, advantages being given to him at all. Meanwhile, judge argued that those were a range of admissions for claimant, which judge failed to list, as there is simply nothing to list. unless disadvantages and complete ignorance by the employment tribunal, thoroughly detailed in an EAT1 file. At the same time, it was open cooperation with the respondent by judge in a claimant absence. At 20 of April 2020, judge openly advised to respondent in claimant absence. I have a fact, I have recorded it, but I was not in the room, to make an application to strike out the case under the Rule 37. Also, judge informed respondent that ET will keep the poor ignorance to any or claimant application as it was during the last 2 years since 2017. The full details of the verbatim transcripts of the second preliminary hearing, which I have and I submitted in a file, shows this dirty cooperation in my absence between marionette judge and respondent. Before and during second preliminary hearing, all parts were informed in written, because it was a telephone hearing, that there is a clouded 24/7 CCTV in claimant flat, and it could not be stopped. The video recording was opened, and the transcripts of it must be accepted as the sharpest proof that Judge Manley do not follow Part 2 of the judicial conduct about judicial independence, dignity, impartiality, and integrity. The grounds number 3, the full absence of the intellectual honesty and impartiality on the money claim. I'm talking now about its many reasons of, there are many claims, and the strongest, absolutely unquestionable and mathematically proof, it's a wage scam claim, because Lidl are manipulating, and like any big companies in the UK, are deliberately creaming unlawful wage deduction from own employees. Even in the case, I'm talking about wage deduction claim, even in the case that there is a clear mathematical breakdown for each of 13 payments I received a Lidl 13 payments, and all of them was breakdown on the 13 simple bundles, which has in every single bundle bundles. This payment was additionally bundled to the group of payments such as working hours, overtime, London allowance, night premium, holiday adjustment, sick pay, statutory sick pay. I'm talking now about core bundle in each bundle of the calculation. It ignored the money claim, which is the Annex K, for over 2.5 years. It's obvious the judge was simply abstracting to give any comment. It was made through a penny breakdown of the 13 payments, which are split as a working hours, overtime, London allowance, pay sick, and etc. Sorry for repeating. Judge ignored to make any comments for 2.5 years up to the date of the final hearing, full hearing. Despite on a constant written request and the verbal request at preliminary hearing on the 20th of April 20, on the 20th of August 20, it was ignored. Transcript of the second preliminary hearing on the 20th of April 2020 included in the judgment set. At the last preliminary hearing on the 20th of April, at the last preliminary hearing on the 19th of May 21, judge even refused to record the verbal evidence. For sure, Annex was simply called complicated to follow, despite that the judge accepted that respondent pay system is very complicated. Judge placed the supplementary deduction as a night shift leader as a main point to declare that the claim has no sense, because claimant is not night shift leader. And just by picking up some small deductions for, let's say, 70, 80 pounds, which included in the main calculation. As a night shift leader, because I was the oldest night team member in a staff, and Lidl need to have a night shift leader, but for night shift leader they need to pay £1 extra per hour. And this is why they never putting a night shift leader. And I just use this small part, this bond, to build a full skeleton of the scam, to show every single part where they're stealing. However, judge from all these calculations pick up a reasonable fact that Lidl are deducting this money because they don't have a night shift leaders in any shops. She just dismissed all my calculations. It is obvious absence of the intellectual honesty and diligence. Also, judge ignored to record that the same year respondent lost an unlawful deduction case. The full details in the file appeal, particularly points 1 and 3. See also points 29 and 31. There are 2 months when even the national minimum wage was not paid. Employment Tribunal failed on the requirement of the section 7.3e regarding the witness statements and obligations to request additional evidence, particularly about the disclosure of the relevant reports, which are the suspension reason. Additionally, respondent did not comply with the various orders. The request to apply section 7.4b of the same act was rejected by judge with no reasons. See the judgment. And the final point, number 5, the key of the hearing is to allow to audio record the last evidence. It is seized all options to record the course of the preliminary hearing and accepted respondent verbal request under the rule 37. In the meantime, ET has rejected claimant request to order respondent to outline in written the points of this application under the rule 37 to strike out the case because of the vexatious and inadmissible claimant behavior, and to include it in a bundle. ET rejected to postpone, and by this to give the ability to unrepresented claimant to reply to the allegations in written. Claimant disagree his behavior as a vexatious and scandalous. It was fair, his behavior, my behavior, at any stage, compared to the proportion of the lawlessness with the full unofficial privilege by MI5 from the core. Now we go